Hi, this is immigration attorney Misbah Chaudhry. Today is June 29th, 2020. It's a Monday and 4 o'clock. So I'm before you with your questions, with your concerns for immigration, and give you the live update, whatever is happening in the world of the immigration law in US. So briefly, I will try to pinpoint some questions. Number one, some concerns. Number one, I have received questions on LinkedIn. I have received questions on Messenger. I have received questions on via email. So I was trying to figure out those questions and to answer them. We cannot be on the separate platforms and answer separately. So it's better if you are live, you are watching us live, you can question us over here, brief questions which we can answer in as much possible manner that can be possible. Okay, before going to certain questions, also during the last week, what I have received, the certain concerns which are again and again questioned are with regards to the presidential proclamation. Again, there are so many questions. People seem to be very confused on that, and I will try to clarify certain things which are questioned again and again. Then mostly we have been questioned about the form I-944, which is the form subject to the public charge grounds of inadmissibility. The people who are filing for the adjustment of status, they have lots of questions with regards to this form, because this is a new form and it needs to be filed for the people who are submitting form I-485, which is the adjustment of status, and they have to submit this form I-944 along with the adjustment of status application for the green card application. And I will explain a little bit. I will try to explain that what is the importance of this form, why you have to submit this application along with your main adjustment of status application. Otherwise, they will return the application, or they will refuse or deny the application which you filed with the immigration for your adjustment. So over here, we will briefly discuss that. Before that, I will try to put some light on typically, which I have explained before also, but it seems like that still many people have question about that. Many people who are already outside United States have a valid H-1B or have a valid visa. It's not that they are asking for the visa again. They are going to the consulate, or they're going to the consulate for stamping, or they're applying for the new visa. They already have the visa issued. They are on that status, but they are outside of United States. So they are very worried that whether they are allowed to come back, their visa is still valid. Yes, their visa is still valid. You are allowed to come back, and it specifically says in the proclamation, it says that it suspends the issuance of the visas for those seeking entry pursuant to H-1B and H-4, which are the H-1B dependents, then H-2B and the dependents, then J visa and their dependents, also the J visa not fully included. It restricts to interns, trainees, teachers, camp consuls, au pair or summer work travel programs, and any foreign national accompanying or falling to join them, that is their dependents. Then the L visa and any foreign national accompanying or falling, that is the L2. So the restriction applies to that for the non-immigrant visas. The proclamation will only apply to an individual. Now, this is very important. This is answering your concern for all the questions which I am receiving from the people all around the world who are outside the United States, and they are questioning me that. So it says the proclamation will only apply to an individual identified above if they are, number one, outside the United States on the effective date of the proclamation. So they are outside of the United States on the effective date of the proclamation. Number two, do not have a non-immigrant visa that is valid on the effective date of the proclamation, and do not have an official travel document. So it clearly answers many concerns that the people who are outside of the United States and they have the valid visas available, there is no restriction applied on them. They can re-enter United States, no problem. The people who are sitting outside of the United States and are planning or were planning to apply for the visas are coming, these particular visas which they have mentioned, H1B, H2B, J1, L1, certain J1s and L1s, L2s or H4s, they won't be able to get that until December 31st, 2020. That is extended for the 6 months time period. Exemptions. Now I'm reading from here because you know that this is what is on the paper. It's not just I'm saying it. I'm reading it for you guys so you can easily understand that this is on the paper. The proclamation will not apply to the following individuals. Number one, lawful permanent residents. The people who are traveling outside of the United States, who are present outside of the United States, they have traveled outside, they are lawful permanent resident, there is no restriction on them, they can re-enter United States, no problem. Number two, spouse or child of a U.S. citizen. So the people who are the spouse or child of a U.S. citizen, any individual seeking entry to provide temporary labor essential to the U.S. food supply chain. Number four, any individual whose entry would be in the national interest as determined by the Secretary of State, the Secretary of Homeland Security, or their respective designees. So I think so they're very clear on which kind of people they apply, on which kind of visas they apply, on which kind of visas or people they do not apply. So I think so this should be very clear explanation for the people who have been sending us questions of whether this applies to us or this does not apply to us. Again, I have mentioned earlier also, keep this in mind. The consulates, the visas which are issued after the interviews through the consulates or the embassies, the non-immigrant visas or the immigrant visas, they are already in delay. They are in delay because of the COVID-19 and because of the situation and the lockdowns and the delay in the in-person interviews conduct. And once there is a delay in immigration, the delay lingers on because it gets into the backlog. So the thing is that that delay is not only just because of this proclamation. The delay can be because of even on the people on which it does not apply, who can go and apply for the visas that clearly says the spouses of the U.S. citizen, their children, green card holders. You know, these people on them, that the delay can be because of the delay in the interview, or the delay when they will schedule the interview, or where there will be the availability, slot availability for the consulate officers or the embassy officers to conduct the interviews to these people. So please keep this in mind as well, that this is also very important. It's not just the proclamation or the restriction that has been applied. It can be because of the embassy slow down work anywhere, and the things get into other cases, get into the backlog, and the process slows down. So that is also one of the biggest factor which everybody should keep in mind. That is one. Okay, we will over here I will like to discuss briefly the form I-944. It's the explanation of the form I-944 is Declaration of the Self Sufficiency. That means that this is for any person who is applying for the adjustment of status within United States. Adjustment of status means they're applying for the permanent residency, or they're applying for the green card process in common language. And they usually, what happens is that when you apply for the adjustment of status, you have to apply for the affidavit of support. The petitioner provides the affidavit of support saying that this person will not become the public charge. The beneficiary, the intended immigrant, will not become the public charge. That is, he is self-sufficient. So this is another kind of declaration included in along with the form affidavit of support I-864, where the attorneys were submitting along with the affidavit of support form the tax returns of the petitioners and the sponsor, or their bank statements and their property documents, the proof that they have enough property available, or they have enough sufficient funds available where this person will not, they are sponsoring, will not become a public charge, and they will be responsible for that. So this form is added in the form I-944, Declaration of Self Sufficiency, has been added in, claiming further things, which says that, I will explain, I will read it to you again, I will read it to you so it becomes clear. It's not that we are just saying it, it's we are reading it from the clear instructions by the Department of Homeland Security. It says that the form I-944 is used to determine whether you are inadmissible to the United States under INA section 212A4 because there is a likelihood that you will become a public charge at any time in the future. So this is very important, that how to explain it. What does it mean? What immigration needs, or what Department of Homeland Security needs from you when you are applying for the adjustment, when a sponsor is sending the affidavit of support form, why they want to add in this form? Because this is a kind of documentation, this is the kind of the statement, what it explains, that it determines whether you are inadmissible to the United States under section 212A4 because there is a likelihood that you will become a public charge at any time in the future. And this forms helps them to evaluate, helps the DHS, Department of Homeland Security, to evaluate whether you are inadmissible by weighing all the positive and negative factors related to your age, health, family status, assets, resources, and financial status, education and skills, prospective immigration status, and period of stay. So other than that, they also, this is an additional form to the form affidavit of support, the form I-864. They and further on they said that they do consider the I-864 form also. It's not that they are not going to, or they are going to waive the affidavit of support form. They are going to keep on following the affidavit of support form, but in addition to that, they are going to consider this form also to see, to check your, evaluate it, and to check your admissibility grounds. Further, who is exempt from filing form I-944? So some people say, okay, I'm on WAWA here, or I'm on WAWA, or I'm an asylee status. Does this, when I go and apply for the adjustment of status, does this form applies to me? Do I have to submit this form along with my adjustment of status application? So there is a list of exemption what immigration has given, saying that, you know what, if you are under the following status, this does not apply to you. So they said, what list is that? It's WAWA people as a special immigrant juvenile, certain Afghan or Iraqi nationals, an asylee, as a refugee, a victim of qualifying criminal activity, the U visa, under any category other than the INA section 245M, but you are invalid, you non-immigrant status at the time of your filing for your adjustment. Then under the, as a victim of the human trafficking, which is the T visa, it says under the Cuban Adjustment Act, for battered spouse and children based on dependent status under the Haitian Refugees Immigration Fairness Act based on the dependent status of the Haitian Refugee Immigrant Fairness Act, under the Indo-Chinese Parole Adjustment Act based on the continuous residence in the United States since before January 1st, 1972 registry, under the Americans Homecoming Act as a Polish or Hungarian parolee, Nicaraguan or other Central American under Section 203, American Indians as a spouse, child, or parent of a deceased soldier under the National Defense Authorization Act, which is NDAA. So it gives a detailed list of the people who are exempt. So if you are an asylee, you are at the asylee status, you have already applied for your asylum application, you got the asylee status, and now 1 year has passed, and this is the time for you to apply for your permanent residency status, which is the adjustment of status. At that time, when you apply for that application, you do not need to include Form I-944 along with your 485 application, along with your adjustment of status application. Similarly, U visa, victim of violence, T visa, trafficking violence, then it's certain special immigrant juvenile cases, Afghan cases or Iraqi nationals, refugees. These are the people who are, when they apply, when they become eligible for the adjustment of status and they apply for the adjustment of status, they are not supposed to file the Form I-944 along with their application, adjustment of status application. So these people are exempt. Other than that, other categories, other than this, when they become eligible for filing for the permanent resident and they move forward for filing the adjustment of status and they file that application along with the affidavit of support application, they have to add in this Form I-944. Again, the name of the form, which we have explained earlier, to show that you will not become a public charge. In admissibility form, they are also mentioning this form as then becoming a public charge at any time in the future, or the inadmissibility form. So you will not become a public charge on the grounds of inadmissibility. So this is the explanation of the Form I-944. As I will receive more questions with regards to this form and with regards to the submission of the forms and the applicability of this form, I will definitely try to answer them as well. Thank you. We have Madia on line, and hopefully she has some questions, and if she wants to ask us questions, we are here to answer them. Other than that, I have like 15 minutes. I will try to answer the questions which have been asked. We are not going to mention the full name. I'm only going to mention the first name because of the privacy reasons. And number two, there is also one concern which I will mention towards the end. So we will first deal with the questions. So first question which I received, it was on LinkedIn, I believe. It says, on whom the Form I-944 applies? Ricardo's question. So Mr. Ricardo, I've already explained, tried to explain in detail, and further once we receive more questions, we will try to explain the Form I-944 for your clarification. But I have briefly explained that, on what kind of people it applies, and what are the people who are exempt, what kind of visas, when the people who are on that status, when they apply for the adjustment of status, they are exempt to fill in and submit Form I-944. Second question is from Mr. Irshad. It says, does the presidential proclamation applies to the E2 investment visas? No, Mr. Irshad, the proclamation does not apply to the E2 visa. They have not mentioned. They have mentioned that these applies to the non-immigrant visas, which are basically H-1B, their dependents as H-4, then J-1, their dependents, and certain types of J-1s, not all. Then it's the H-2B and their dependents. And then there are for the L visas and their dependents, the L2s. So it depends on those kind of non-immigrant work visas. Third question is from Mr. Deepak. He says that if I have already issued H-1B visa and I was visiting India, does that restriction applies to me? So as per my understanding of the question, Mr. Deepak wants to ask that he's already in India, he's on valid H-1B status, and he went to India to visit, and now he wants to come back. So does that restriction applies to him, or he is allowed to re-enter United States? So the answer to this is, Mr. Deepak, that yes, you can re-enter to United States. You have already valid H-1B visa, and there is no restriction as such that applies on your entry. So you have the visa available. You can enter United States on the H-1B status. Then we have this next question from Christina. The question is, does the restriction apply to the L2 dependents too? So I believe I have answered this one also. Yes, as this restriction applies on the L1 intra-company visa holders, that is when one company is sending its employees on the executive or managerial visas to US, or the skilled worker visas to US, specialized knowledge workers, and their dependents come along with them. So if you are on the L1 and the L2s are coming along, the restriction applies to the L2 also. We have one question here which says, can H1B still be applied for the candidate already in USA or F1 or J1? So the people who are already in US, they are not coming in from around the world. So there are two conditions. One is that they already have the visas, they are outside, and they are trying to come in. Yes, the re-entry is allowed. They can come in if they already have that visa. The other situation is this question, which it says that if these H1B still be applied for candidates already in US, or if they are in US on F1 status, or if they are on US on J1 status. No, it does not apply to them who are already in the US in that status. So it applies to the people who are trying to enter United States, right? There is another question which says, the question is from Mr. Vincent. It says, does the restriction applies to the immigrants within the USA at the time of the proclamation? So again, I think so I just answered it. It's linked, the same question, that does the restriction applies for the immigrants within the USA? No, this restriction does not apply to the people who are in the current status within United States. It does not apply to them. Only to summarize again, for clarification, it applies to the people who are planning to apply for this kind of visa. So if they are people, even see, there are non-immigrant visas starting from A to Z. So people who are trying to come in on the performance visas, the entertainment visas, P3 visa, or they are trying to come in O visa, or they are trying to come in US on a B1, B2 visa. So apparently on this proclamation, it does not say that this restriction applies to them. Though they are also non-immigrant visas. Then there are people who wants to come in on the religious visas, the R visa, or on the Q visa. There are so many categories they can come in, and it does not apply. The four visas, the four type of the visas which are mentioned, or the non-immigrant statuses which are mentioned specifically here, are the H1B related H4. Then we have L1 related L2 dependents, then we have H2B related dependents, and then we have J1, and that J1 also applies to certain kind of J1. So that I have already listed, but again, I will, for your clarification, for the people who have just joined us and want me to repeat it, it applies to interns, trainees, teachers, camp counselors, au pairs, or summer work travel programs, and any foreign national accompanying or following to join them. So even under the J1, the restriction does not apply to all kinds of people. It applies to the certain areas which is included over here, which I have just mentioned. So I think so we have answered quite some questions. There is one more concern which I have repeatedly been questioned, and because we are lucky enough to have been very familiar and fluent with several languages at our law firm. So at our law firm, we have people who speak Spanish, they speak Punjabi, they speak Pashto, they speak Hindi, they speak Urdu. So I have this concern, they have understanding of Persian language. So I have this concern that they are saying that if you can, and I'm mentioning this language because specifically that was in the question, that if you can have your live telecast in, say, some live telecast in Urdu language, or in Hindi language, or in Punjabi language. So yes, we will try, and I think so it's a very good idea. For the better understanding the people who have the restriction in the English language or some restraints in them, and they are more comfortable in understanding their own language, or more comfortable in understanding or asking us questions in that. So we will definitely try to add in some of our live programs where we will do that in the other regional languages, or where people who are interested in listening to that translation. You can add in the translation also, but anyways, if they are interested in adding in, we can use that. Then there is another question, live telecast in Urdu as well, please. Yeah, there is another concern that if you can do the live telecast in Urdu language. So we will try to do that also, live telecast in Urdu as well as Hindi, Punjabi. We will try to add in Spanish language also. So there is more understanding of, there are certain languages or there are certain legalities which I think so people are more comfortable in understanding in their own language also, and as a first language. So I will definitely, we will think about it, and we are planning to get that done as well. Any questions? Again, I'm mentioning it. If you have any questions, kindly direct. If you are watching online, sometimes people are screen shy. Sometimes people are they have questions in their mind, but they send me email or they send us the LinkedIn or Messenger. On Messenger, they send us those questions. So if you are live, you can ask us questions. We are here to answer the questions, but make sure that the questions that you ask are brief. They are not very long questions, and the personal facts are not involved, because some information is privileged. We cannot discuss it. Then if we cannot give long answers or detailed facts involved in any kind of question, so would kindly make it brief questions so we can briefly answer those questions, and other people who are listeners, other listeners who are here, who are watching us and liking us, thank you very much. Those people also can have the understanding of the basic immigration law that relates to that issue. So they have the answer to that question. I think so. We have a very good session. I will like to have a program, live telecast in detail about the form I-944. There are lots of concern about there. Next week, I'm thinking about, let's talk about the remote proceedings, how it works, what happened to the people who get into the remote proceedings, how the procedure works with the EOIR. EOIR is the court system, immigration court system, how it works over there. So I will try to give you a brief idea of what happens. What is an NTA? What is the notice to appear? These are very important things. And I think so as immigrants, the people over here or around the world who are listening to us should know, have a good idea of what goes on. So we will try to summarize different sections. Immigration is a very vast law, very vast, very widespread law. And I think so covering it is not that easy. We try our best to cover whatever concerns come to us and clarify the system to the people who are immigrants or intended immigrants, so they can have a better understanding of the whole procedure. Further, I would like to talk also about asylum. Many people have sent me question about that. Oh, if you can briefly tell us about the asylum process, how it's working, what are the restrictions coming on the work authorization related to asylum. Further, people have their concerns about the finances. People want to know that if they, once they are in United States, is there any help they can get, financial help, or is there any financial help? Not means that they become a public charge. Financial help means there are certain people who wants to do business over here. The people who are like, once they come here, they wants to build their credit. So how they can do that, how they can help, they can get help with regards to it. There's so many institutes, banks, so many institutes which can help you, companies, financial institutes which can help you get on your feet and meet your dreams. There are entrepreneurs who want to start their businesses. How they can do that? They are new in this country. So we will try to touch all these topics for you. So it's better for you to get the basic ideas, and then you, if but any kind of questions come into your mind, you can easily ask us those questions. We will try to answer those questions. And as per the new laws which steps in, new regulations, new notifications come in, we will definitely discuss also. You will see the sliding address. We will see our address on the slide. You will see our email address there, our LinkedIn. We are on Twitter. We are on Instagram. We are on Skype. Also, we have a YouTube channel, we have our website, so you can get that information. Everything is available on the screen, and you can like us on the Facebook page, so you can get all the notifications from us and all the updates from our end. Whatever comes into the immigration world of the United States, we love to keep you posted on that. Any new rule, any new notification, any new proclamation, so you know what's going on in the world of the immigration. Thank you very much. Thank you for listening to us. Thank you for viewing us. And hopefully we'll get more questions and more participation. And again, thank you very much. Until I see you next week. Stay well.